Okay, this is the last topic under partnership law, which is the dissolution of partnership, pemubaran, perniagaan, perkongsian. So how actually a dissolution of partnership could occur? It could occur under the following situation, under the following circumstances. Number one is dissolution by agreement. Number two, dissolution by expiration. And these also can be done by notice. Okay. Number three, dissolution by supervening illegality. Number four, dissolution by death or bankruptcy. Number five, dissolution by charge on the partner's share of the partnership property. Number six, dissolution by the court. So dissolution by the court, this is under section 37. This can occur because of mental illness, permanent incapacity, prejudicial conduct of the parties, of the partners, willful or persistent breach by the partners, loss in making business, just and equitable relief. So let us go on with dissolution by agreement first. A partnership, a business of partnership, it can be terminated or it can be dissolved through agreement of the parties, meaning through mutual agreement of the parties. So if the duration of the partnership has been specified in the agreement, then of course, okay, it will be terminated at the expiry of the period of the partnership. It's been formed for 5 years, let's say. So now is the end of 5 years. Of course, automatically it will be terminated. However, it can also be terminated upon mutual understanding, meaning all partners mutually agree to dissolve the partnership, then the partnership will come to an end. Okay, dissolution by operation of law. These are the situations whereby the dissolution can occur because of expiration. So if a partnership is being formed for a fixed term, now it comes to an end already, had expired, the partnership automatically will dissolve. Or if let's say under section 34(1)(a) just now, so now we are going to go on with section 34(1)(b), whereby if a partnership is being established for a single occasion or enterprise, so it will dissolve once actually that occasion or that enterprise comes an end. So let's say you form a partnership to sell souvenirs during the convocation. So now the convocation had over. The ceremony had over. It comes to an end automatically. The said partnership also comes to an end. So let us have a look in the case of Moss versus Elphick. So in the case of Moss versus Elphick, the partnership was being formed for undefined period of time. However, there is a clause in the partnership agreement saying that it could be terminated by mutual arrangement only. The words there is only. So there is no other way how it can come to an end, right? Then this Moss gave notice to Elphick. He wanted to dissolve the partnership. The court held actually this notice is invalid. Why is it invalid? Because the words there, that partnership can only be terminated through mutual arrangement. So, okay, let us have a look in the case, in the situation whereby the partnership can be dissolved through notice. So, this kind of termination can occur if, let's say, the partnership is for undefined period of time, like the case of Moss versus Elphick just now. So if the partners wanted to end the partnership, they can give notice to the other partners. However, why actually in Moss versus Elphick, the court held actually the notice is invalid? Because under section 28, this is subjected to the agreement between the parties. Yes, if the partnership is being formed for undefined period of time, it can come to an end, it can be terminated by giving notice. However, it is subjected to an agreement. So in the case of Moss versus Elphick, there is written agreement. The written agreement clearly stated that the partnership can only come to an end through mutual agreement only. Because of this agreement, that's why in the case of Moss versus Elphick, the court held actually the notice is invalid. So the date of dissolution, if it's through notice, is as mentioned in the notice. And if there is no date, then the date of communication of the notice will be taken as the date of dissolution. And this notice to dissolve is not need to be in writing, so long as the other parties is being informed of the said notice to dissolve, then this is considered as a valid notice. So let us have a look in the case of Tam Kok Cheong and others versus Low Hui Heng. In this case, there are 4 partners in the said firm, and 3 of the partners, they wanted to sell off this firm to a limited company. So meaning they wanted to dissolve the said partnership. So when they conduct the negotiation for sale, they did not inform the 4 partners. Okay, so the 4 partners is aware about the dissolution, about the selling of the said firm only on the date of sale, which is 6 April 1966. So that's why now the 4 partner says that he was not being given notice, and because of that, this transaction is not valid. This dissolution is not valid. However, the court held actually the conduct of the partners in selling the firm to the limited companies, this shows that they have an intention to dissolve the partnership. And the 4 partners actually have notice of the dissolution on the date of the sale. So this notice to dissolve no need to be in writing, as I told you earlier. It can be done through conduct. Okay, so dissolution by supervening illegality. So this is something which is similar to discharge of contract, which I have taught you. Discharge because of impossibility. Discharge of contract because of frustration of contract. Okay. So if a partnership, this is under section 36, okay, student. If a partnership is being formed, when it's being formed, it's a legal partnership. However, later on, it becomes illegal because of certain circumstances, or maybe because of new set of law, new set of legislation, which made it illegal. So let's say there is a partnership in existence between this Malaysian firm and a Singapore firm. And suddenly now, Singapore becomes a Malaysian enemy country. So automatically, the partnership is dissolved because of illegality. Or maybe this is a partnership which is being formed to sell vape. This is an electronic cigarette, right? And suddenly there is new set of law which says that selling of vape is illegal. Then under that situation, the partnership will be dissolved because of illegality. So let us have a look in the case of R versus Kupfer. In this case, this involves 2 brothers. They are actually partners. One is in Frankfurt and the other one is in London. So this Frankfurt firm make an order from a Dutch company in Holland. During the World War, Holland and England, they are enemies. Okay, and he make payment in Holland, and the payment is being done by the London office. Because of the war, and now the 2 countries become enemy. Because of that, now the partnership is being dissolved because of illegality. Okay, dissolution by death or bankruptcy. So if there is no agreement saying that if one of the partners dies or one of the partners become bankrupt, then the partnership can still goes on, then automatically, if one of the partners dies or one of the partners become bankrupt, then automatically the said partnership will be dissolved. So dissolution by charging on shares. This is under section 35, section 2. These are the situations when if one of the partners charge his share. Why he charge his share? So let's say he wanted to borrow money from the bank, wanted to take up a loan, and as security, he's charged his part of the partnership. Let's say he have his share is 50% of the said business, and now he wanted to charge this as security for his loans. Okay, then the other partners actually have the choice to put an end to the partnership. They have the choice to dissolve the said partnership. Okay, so now we go on with regards to dissolution by court. So a partner can apply to the court to dissolve a partnership in the case of mental incapacity, permanent incapacity, conduct which is prejudicial to the partnership business, or if there is persistent breaches of the partnership agreement, or the partnership is being carried on at a loss, and the dissolution is being just and equitable. Okay, let's go on with mental incapacity. What is mental incapacity? Mental incapacity is a kind of sickness of the mind, such as insanity, psychopathic disorder or disability of mind. So meaning now the partners cannot manage the property and affair of the partnership. So a partner can actually apply to court. He may apply to the court, or maybe not the partner, someone else, maybe the guardian of this person who suffer mental incapacity. He can apply to court for dissolution of the partnership. However, before the court can give their decision, the court need to have a look at the medical evidence which is being produced to the court. Okay, secondly, when actually application can be made to the court to dissolve the partnership when there is permanent incapacity. This is a situation which covers much more wider area compared to mental capacity. Mental capacity focus on sickness of the mental. However, permanent incapacity covers more than that. So, what is meant by incapacity, permanent incapacity? This depends on the question of fact and depends on the nature of business. So, like myself, if I become if I lost my voice, I become deaf and dumb. Of course I cannot perform my task. So this can be considered as a permanent incapacity because the kind of business I'm involving in, the kind of job I'm involving in, requires me to have voice to talk and speak to the student. However, if let's say I lost my leg, this will not be taken as permanent incapacity because my job does not require me to have a leg. So in the case of Willful versus Arthur, so what happened in that case? So this is a pharmacist, and one of the pharmacists become disabled because he suffered this paralytic stroke. And one of the partner now file for dissolution. Dia mengalami mati badan sebelah, kena stroke, right? So because according to the partner, he is incapable of carrying out his duties in the partnership business. However, the application is being stated by the court. Walau bagaimanapun, permohonan itu ditunda oleh mahkamah. Why? Because there is evidence, actually there is a recent improvement of his health. However, court says the other partners is given liberty to apply to dissolve the partnership if his health deteriorated. Okay, prejudicial conduct. So this conduct either directly or indirectly related to the partnership business. As long as it affects the credibility of the partners, then the other partners can actually apply to dissolve the partnership based on this. So no need for the other partners to prove actually the conduct occur in the course of business or was connected to the partnership business. Okay, in the case of Carmichael versus Evans, Carmichael was convicted for an offence whereby he travelled on a train without having a ticket. So this actually shows there is an intention to defraud, and this actually an offence of dishonesty, whereby dishonesty is detrimental to the partnership. So actually under this prejudicial conduct, there is no need for the partner to prove that actually there is actual loss. Okay, so let us go on with willful or persistent breach. This is the situation whereby the breach can be intentional or the breach can be unintentional. Okay, as long as it makes the carrying of the business in partnership becomes impracticable, whereby the mutual confidence between all the partners now is being destroyed. Okay, then under the situation, one of the partners can apply for the dissolution of the partnership. In Cheeseman versus Price, what happened? So one of the partners persistently made mistakes in bookkeeping, and in fact, he had not entered receipts in the account of company. Of course, this is very crucial, and because of this, the courts allow the application to dissolve the said partnership. Carrying on business at a loss. Okay, so if the business is being carried on at a loss, then the partners may apply for dissolution. However, these losses must be something which is not temporary, because this is normal actually for a business. Sometimes they make profit and sometimes they suffer loss. This must be situation where the loss is a very serious one, whereby the company cannot survive anymore. Okay, so we will look at the case of Jennings versus Bentley. to look. So, okay, so now we continue with the case of Jennings versus Baddeley. So what happened in that case? All capital had been used, had already exhausted, had finished. Okay, and one of the partners now request to the court so that he made an application to the court so that the partnership be dissolved. Okay, though maybe the partnership can obtain profit in future if more capital is being injected in the mining business. However, the court approved the said dissolution because there is no concrete evidence showing that the said business can survive in future. So what happens if, let's say, capital is being injected, however, the business cannot survive? So that's why the court allowed the dissolution. So our last topic today is when the court find that it's just and equitable based on just and equitable grounds that the partnership could be dissolved. So these are the situations where the court is being given wide discretion to order the dissolution. Maybe all the said grounds just now is not applicable here. However, by looking at the facts of the case, the court feel this is something which is just and equitable. Satu yang wajar dan adil untuk dibenarkan. Okay, example, if there is complete communication breakdown between the partners. And if we look at the case of Ibrahimi versus Westbourne Galleries Limited, so this Ibrahimi and Nazar, actually, they are partners. And they actually involved in this buying and selling rugs, and actually their business is very successful. It's very successful. Because of that, they wanted to incorporate it into a company. And both of them, this Nazar and Ibrahimi, they are both sole shareholders of the said company, and they took director salary rather than dividends. Nazar later on appointed his son as one of the board of directors, and both Nazar and Ibrahimi transferred share to him, to the son of Nazar. And then Nazar's son and Nazar himself called a company meeting, and what they did, both of them passed an ordinary resolution whereby they removed Ibrahimi from the said company. And because of that, Ibrahimi is not happy, so that's why now he applied for this application. The court held actually, though this is a company, the court held actually, this is actually a quasi-partnership. And it is actually just and equitable under this situation to wind up the company, looking at the attitude and the conduct of Nazar and his son, and Ibrahimi is being given the capital interest. He received a capital interest. Okay, that is the case of Ibrahimi versus Westbourne Galleries. So in the case of Re-Energy Tobacco Company Limited, so though the business still survives, the business is thriving, however, the relationship of the partners, is at a standstill. They only communicate through the secretary of the companies. And because of that, court held this is a proper situation where actually the company could be dissolved on the application made to the court. So, okay, student, that's all under this topic of dissolution of partnership. Thank you, student.